Hi everyone, and thank you for joining us for March 2019 My PIP Monthly. My name is Javon David. I'm a partner at Secrest Wardle's Troy location. I'm here today with my partner Cleveland Simmons, and this podcast is hosted by myself and Mark Masters, a senior partner at our firm. Per usual, we are going to go through some case law updates from March of 2019. These are cases that came down from the Court of Appeals this month, and we'll discuss what each case held and how it affects your general claim handling. Then Cleveland Simmons will discuss the benefit of outside-of-the-box experts in first-party cases. He's going to go through some options that are available to you, which you likely already know about: biomechanical engineers, occupational therapists, things along those lines that are outside of the typical IME physician, but give you some insight as to how they can be used pre-suit and in litigation to mitigate your exposure on a claim. Now, the first case this month is Northland Radiology versus City of Detroit. The issue on appeal was whether the claimant's statutory right to claim to payment of no-fault benefits was assignable in the absence of an insurance contract. The court ultimately concluded that the claim was assignable despite a lack of contract. So let's go through these facts a bit. So in Northland Radiology, the plaintiff, a provider that typically performs MRIs and things along those lines, filed suit against defendant City of Detroit Transportation for recoupment of various health services provided to the claimant Robert Allen. Mr. Allen allegedly sustained injuries while a passenger on a bus operated by the Detroit Department of Transportation. The city refused to reimburse Northland Radiology for its services, and as a result, the lawsuit ensued. While this case was pending in the trial court, the Michigan Supreme Court issued the notorious decision of Covenant versus State Farm and held that a healthcare provider possesses no statutory cause of action under the No-Fault Act against a no-fault insurer for recovery of PIP benefits. Therefore, defendant moved for summary disposition and argued that Covenant was dispositive of the entire claim, as the plaintiff did not have an ability to sue them directly. In response, as we all saw too often right after Covenant, plaintiffs would move to amend their complaint to assert a claim based on a previous assignment that was collected from the claimant. In this case, the trial court granted plaintiffs' motion to amend, and they thereafter amended their complaint to attach an assignment of no-fault benefits under an assignment of rights theory. Defendant moved for summary disposition, arguing that the amended complaint sought recovery of PIP benefits under assignment of rights theory, which Covenant did not prohibit. In addition, defendant argued that the claimant's right or claim to recovery of PIP benefits under the No-Fault Act was not assignable, and defendant asserted that because there was no contract of insurance between Allen and defendant, Allen did not have a contractual right to PIP benefits to assign, and there is no legal authority permitting the assignment of rights theory. After a very lengthy discussion as to the assignability of a claim or a right, the Court of Appeals ultimately concluded that the assignment is not specifically derived from the contract or policy of insurance. And since the claim was a statutory claim for payment of benefits, that the ability to go after someone like the defendant in this case was viable given the assignment ability of the general assignment law. So the court first went through a long analysis concluding that generally all legitimate causes of actions are assignable. And that's the case of Grand Traverse versus Park Place Motor. It's a 1998 case. In addition, the court looked to the legislature's intent. The court first considered MCL 500.3143, which provides that an agreement for an assignment of a right to benefits payable in the future is void. The court noted it has construed this provision and concluded that the No-Fault Act permits an insured to assign his or her right, past due or presently due, for PIP benefits, but simply precludes an assignment of PIP benefits. So contrary to the defendant's argument, there was nothing in the No-Fault Act that would cause the claimant from not being able to assign his rights generally under the No-Fault Act. The case law is clear about assignments, and the ability to assign does not come from the No-Fault Act. It comes from contract law. So why is this important? Because the general proposition under this Northland Radiology case and the case law that's interpreted within this case is that you don't need to have a policy of insurance in effect in order to be able to assign your rights. The ability to assign rights does not come from the policy, and it does not come specifically from the No-Fault Act. Nothing in the No-Fault Act requires that or precludes someone who doesn't have a policy of insurance from assigning their rights. Generally, all legitimate causes of action are assignable, and therefore the plaintiff was able to obtain an assignment from the claimant in this particular case. Now, the next case from the Court of Appeals is the Rubin versus Allstate case, which provides that if a provider filed suit before obtaining an assignment and subsequently an assignment is executed more than 1 year after the benefits were incurred, then all of those benefits are ripe for dismissal. So in this particular case, the plaintiff provided medical care to the claimant following his injuries in a motor vehicle accident. While the case was pending, the Michigan Supreme Court issued, again, Covenant versus State Farm, causing the plaintiff to obtain an assignment from the claimant to avoid a dismissal. The plaintiff then filed an amended complaint in August of 2017. The defendant, Allstate, moved for dismissal, arguing that the amended complaint was a supplemental pleading and did not relate back to the original filing. Therefore, all claims assigned would be barred pursuant to the 1 year back rule because they were not brought within a year of being incurred. The trial court granted Allstate's motion and held that all benefits incurred prior to June 21, 2016 were barred by the 1 year back rule. During the pendency of the appeal on this case, the Michigan Court of Appeals issued its decision in Shaw versus State Farm, which is currently pending before the Supreme Court. The court in Shaw held that an amended complaint relates back to the original filing date. However, a supplemental pleading does not. The majority in Shaw determined the amended complaint was actually a supplemental pleading, and therefore the relation back doctrine would not save the claims presented in Shaw that were incurred more than 1 year prior to the assignment. After the decision in Shaw, the court in this particular case was bound to follow that majority ruling regarding assignments and amended complaints. Since all of the claimant's medical care was incurred 1 year prior to the assignment issued on June 21, 2017, the entire claim was dismissed pursuant to the 1 year back rule. So the takeaway here in light of the Shaw case, which, we're probably expecting an opinion on Shaw in the very near future from this Michigan Supreme Court, if a provider filed suit before obtaining an assignment and subsequently an assignment is executed more than 1 year after the benefits were incurred, any and all such benefits are ripe for dismissal. If the trial court allows an amended complaint to be filed, it will not relate back to the original filing if the amended complaint is based upon an assignment of benefits incurred more than 1 year before the assignment was actually executed. Now, the next case is Urquhart versus Auto Club Insurance Company. This is an interesting case that deals with something that occasionally comes up on cases, and that is when a deceased party is involved in a lawsuit. Generally, the Michigan court rules provides that if a deceased party, if someone dies in a lawsuit, a motion for substitution has to be made within 91 days of the filing of a notice of suggestion of death. Now, how that is treated by the courts can vary, and this is an example of that. But in this particular case, Orita Urquhart filed 2 lawsuits against Auto Club seeking no-fault benefits after her accident. The medical records were obtained and her deposition was taken twice. After her failure to attend a settlement conference, the parties learned that she had died in February 2017. Counsel for defendant Auto Club filed a notice of suggestion of death pursuant to the Michigan court rules. 91 days passed and there was no motion for substitution by the other side. So basically what happens is one party will say, hey, I'm putting you on notice that someone has died. You have to amend your pleading so that the caption is correct, because the dead person, the decedent, cannot go forward with this lawsuit. You have to open up an estate or get some sort of action taken by the probate court to pursue this claim. You have 91 days to do that, or else your case is subject to be dismissed. So here, more than 91 days passed without a motion for substitution being filed. So Auto Club files a motion to dismiss that was granted by the court. The Court of Appeals looked to the particular language of MCR 2.202, which states as follows. If a party dies and the claim is not extinguished, the court may order the substitution of the proper parties. Unless a motion for substitution is made within 91 days after filing and service of a statement of the fact of death, the action must be dismissed as to the deceased party, unless the party seeking substitution shows that there would be no prejudice to any other party allowing a later substitution. So the court looked to this entire court rule as a whole instead of the ability to just dismiss the case outright, and found that although the court rule provides a 91-day time limit, it is not a bright line rule, but instead can be adjusted if there's no showing of prejudice to the other party from allowing her later substitution. Here, the court looked to a few things when determining whether or not there's prejudice. First, the plaintiff attorney indicated that there are no further PIP claims that would be made beyond what was discussed in discovery and at her depositions. In addition, the plaintiff was deposed twice. She had her written discovery submitted. There was nothing further that Auto Club would have required to adjust the claim going forward. So because all that evidence was already within the record, there was no prejudice in not having the proper party named in the caption. So this is important because often people will argue that, okay, well, you have to certainly substitute in the new party in order to proceed on the claim. But here that's not true. The other side can present arguments that there's no prejudice to you because you've done all your discovery already. So really, I think this comes down to the timing of when the person dies in the pendency of the lawsuit. If it's early on, your chances of getting a dismissal are greater. But if it's later, then you're probably going to have a harder time convincing a judge that you're going to suffer prejudice if this proper party is not named. So the next case that we've got to discuss is the Lewis versus City of Detroit. And this was a pretty drawn out battle between the plaintiff who was seeking payment from a City of Detroit defendant. It was essentially a long covenant fight. But what's interesting about this case is its holding regarding notice of liens. And essentially, just some background here, Ricky Lewis was a claimant injured in a motor vehicle accident involving the City of Detroit bus. Metro Pain Clinic treated Williams and Lewis for their injuries resulting from the accident. Williams and Lewis filed a lawsuit against Detroit for PIP benefits. Metro Pain Clinic filed a separate lawsuit against Detroit seeking reimbursement for the cost of treating the two claimants. Metro Pain Clinic's lawsuit was a direct cause of action and not based on an assignment from Lewis or Williams. These cases remained separate for nearly the entire trial court proceedings. In Metro Pain Clinic's case, counsel for Detroit and Metro Pain Clinic informed the trial court that Detroit and Metro Pain Clinic agreed to a settlement pending Detroit City Council approval. Counsel for Detroit explained that City Council could elect to not approve the settlement, and he was unsure when the council would make the decision. This also happened in Williams' case as well. All right, so that's all of the case law to discuss this month. Now I do have my partner, Cleveland Simmons, to talk about different experts you can use pre-suit and in litigation to help mitigate your exposure in claims that go beyond the typical IME physician. Hi, Cleveland.
Oh, hi, Javon. Thanks for having me. So what we're going to talk about now is just outside-the-box experts that you can use in PIP cases. These are experts that are different than your typical IME experts, which people usually get, pre and during litigation. The first type of expert we'll talk about is a nurse case manager. What Javon and I see a lot in our catastrophic cases are people who need an extreme amount of attendant care services. Nurse case managers are really helpful in this aspect because they treat people on a 24-hour basis, and they're able to go in, take a look at someone, and determine if they actually need the amount or even the type of care that someone is getting.
I completely agree. I find a nurse case manager to be incredibly helpful on those large attendant care claims. Even if large can be subject to interpretation, but even something 6 to 8 hours, but definitely those 24-hour attendant care claims, a nurse case manager can review the records, understand the treatment, and determine, number one, the reasonableness of the rate and the reasonableness of the amount of hours. And it gives you a qualified expert that routinely deals with attendant care issues to be able to testify for you throughout the case and at trial. And I think that resonates much more strongly than just an IME physician saying that the attendant care is not necessary or it's necessary at a reduced amount.
And additionally, in Michigan, attendant care services are seen as medical. So this is something that lasts forever as opposed to your typical household service, which only lasts for 3 years under the No-Fault Act at $20 a day. In Michigan, Javon and I have seen people try to claim up to $30 or $40 per hour for years for just a mother or maybe a son helping out a dad, or even bringing in someone from the outside. So getting a qualified expert who's a nurse case manager can really help mitigate these types of damages and help with a case. The second type of expert we want to talk about is an accident reconstructionist. With most SIU cases pre-litigation, you may have claims where you think an accident is staged, or it may be an accident, but maybe a vehicle isn't involved. This can involve a claim. So it's important to get accident reconstructionists involved as soon as you can. And accident reconstructionists typically like to see things like an EUO or a statement under oath. This is where Javon or I or our law firm can come in handy pre-litigation to do a EUO or an SUO of a witness to figure out exactly how an accident happened. And it's also important to keep the vehicle if you do total it out, if you want to get an accident reconstructionist, because they can also go in, take a look at the vehicle, assess the damage, and tell you what type of accident, if any accident at all, actually happened. So the next type of expert we want to talk about is a biomechanical expert. Biomechanic experts and accident reconstructionist experts typically go hand in hand, but biomechanical experts can help assess forces involved in a motor vehicle accident, because typically you'll see in even a minor rear-end collision, a plaintiff may complain of injuries from their head all the way down to their legs, even though the damage is only minor. Now, biomechanic experts are very valuable because it helps the jury understand the forces involved, and it's a lot better sometimes than just having a doctor show up and say the person's not hurt. Well, sometimes we need someone to explain in layman's terms why a person cannot get the type of injuries they're claiming from a standard minor collision.
I completely agree with everything Cleveland said. Just to kind of further elaborate, I know we've all used either biomechanics or accident recons, but it's nice to have a little refresher as to their scope and specialty, and how you're using them either pre-suit or in litigation with your counsel. So for biomechanical engineers, from an engineering perspective, a biomechanics expert's training includes an understanding of how different parts of the human body react to external forces and how those stresses and strains develop in tissues to cause various injuries among the claimant or the person involved in the accident. So their training is specifically intended to understand the anatomy and physiology in conjunction with various medical diagnoses to classify injuries and whether a certain force can even cause or exacerbate a pre-existing injury or cause a new injury. It's a combination of medical knowledge and the engineering aspect of an accident to help you further understand how this person was hurt in an accident, if at all. And you're going to want to still remember that medical doctors and biomechanical engineers are not one and the same. So while you can use a biomechanical engineer to comment on force and its effect on the body, you still need a medical doctor to discuss causation and an injury?
The last type of expert we want to talk about is a vocational rehabilitation expert. Typically, we hire these types of experts to analyze a person's wage loss claim because in Michigan, even though wage loss benefits are only available for 3 years, you can see a wage loss claim up and above, I believe it's over $5,600, and over a 3-year span, a wage loss claim could become very expensive. So it's important to get a person or to get documents to a vocational rehabilitation expert to determine if this person can do anything else in their life, because a PIP case is just a breach of contract claim. So having a vocational rehabilitation expert helps to mitigate some of the damages on that end.
Right, and you can use them in your BI cases or even on your PIP cases if someone's saying, well, I used to be a home health aide and I can't lift anyone any longer. Well, there's still things that you can do with that kind of skill level and experience. And if you're going to fight on this particular wage loss claim, you're going to need someone to talk about what this person can do to continue earning an income so that they are not simply just coming to the first party carrier for PIP benefits or to the bodily injury carrier for excess economic wage loss.
And lastly, like Javon said about the biomechanics expert, a vocational rehabilitation expert typically isn't a physician, so you wouldn't typically notice this up like your regular IME. But if a plaintiff counsel pre or even during litigation will let a vocational rehabilitation expert see your claimant or plaintiff, that's obviously a plus. But even if they won't, getting things to a vocational rehabilitation expert like an EUO, an SUO, or a deposition transcript, even answers to interrogatories, statements even in your claim file can go a long way with figuring out what this person can and can't do in the future based on the skills that they've acquired over their lives in order to mitigate their wage loss claim.
All right, so those are just a handful of suggestions that we have for you so that you're not, just kind of looking at a claim and thinking, okay, I'm going to send this to, an IME doctor to review the injuries, tell me if this person can go back to work, and how much I'm supposed to be paying or not paying on a particular claim. You're going to want to really set up your case nicely so that if and when it goes into litigation, you've got all your players in place, whether it be the nurse case manager to refute the attendant care claim, the accident recon who told you whether or not the accident happened, the biomechanical engineer who truly provided an overview of the mechanism of injury, whether this kind of accident could have caused the kind of injury claimed, or a vocational rehab expert. And sometimes, you'll get a claim in and you'll think, wow, this, the person reported no injury at the scene, but I'm seeing all of these providers, I'm seeing all of these neurosurgeon bills coming in. It just seems out of proportion to what I believed the injury was and what the medical records substantiate. Well, your IME doctor is going to help you there, but these additional experts will insulate you from any further exorbitant claims or provide you with an ability to rely on them in the denial of a claim or the adjustment of a claim generally. So if you have any questions about how all of this can work, if you need any recommendations, please feel free to reach out to Cleveland, myself, or Mark Masters, and we'll be happy to steer you in the right direction in terms of the kind of expert that you're looking for and maybe provide some suggestions that people that we have found to be helpful to us on our cases. So thank you, Cleveland, for joining us this afternoon. We look forward to seeing you guys join our podcast next month.